Welcome to my channel. I'm Advocate Manjit. In today's video, we will discuss whether is it possible for a flat in a cooperative housing society in the state of Maharashtra belonging to a deceased person be transferred in the name of his legal heirs without getting a heirship certificate from the court of law. And the answer is, well, of course, you can get that done. There is an alternative to getting a heirship certificate. So what exactly is the procedure for that? That is something that I will take you guys through in this video. The first important thing is what exactly allows you to do this is the bylaws, which is nothing but basically a set of rules which govern the functioning of the cooperative housing societies in Maharashtra, allows you to get the names transferred to the name of the legal heirs without getting a heirship certificate from the court of law. So I'll explain this all with the help of an example, so it's very easy for you guys to understand as well. So for example, X is a deceased person. He has a flat in a cooperative housing society in Maharashtra, and after the death of X, he is survived by his wife, a son and a daughter, who are basically his legal heirs. Now after the death of X, if the mother, the son and the daughter want the flat to be transferred onto their names, what exactly is the procedure that they have to follow is something I'll give you in details right now. So let's simplify this further and take two examples under this. So for example, in one scenario, the son and the daughter do not want anything and would want the flat to be transferred onto their mother's name, that is wife of X. So, and the second situation would be the daughter does not want anything and wants it to be transferred onto the name of her brother and her mother, basically the son and the wife. So taking one by one each scenario, so talking about the first scenario, let's go through that first. So in this first scenario, the son and the daughter do not want anything. They just want the flat to be transferred onto their mother's name. So what you need to do, the mother, that is the wife of X, would have to give an application in writing to the society saying that she wants the flat to be transferred from the name of X to her name. Apart from that, she would also have to make an affidavit on 100 rupees stamp paper, giving in the basic details starting with her name, the age, occupation, the address. Then she'll have to give a brief history of X owning the flat in the society, the number of shares that he holds with the society, the serial number of the shares, all of that information has to be given. Then she will have to mention the date when X expired, also the details of all the legal heirs of X. So she will have to mention her name, saying that I'm the legal heir, I'm the wife, he has a legal heir, the son, the daughter is also the legal heir. So all of these three persons are legal heirs of X. Then she will have to further mention that the son and the daughter do not have any objection to getting the flat transferred on the mother's name, that is wife of X. So that's all that will go into her affidavit. Now along with this, the son and the daughter would have to give an affidavit cum no objection. In that, they would again have to mention their personal details, the name, age, occupation, address. They would have to give a brief history of X owning the flat, the number of shares that he had, the serial number of the shares, then followed by the details of the legal heirs of X, similar to what is mentioned in the mother's affidavit. The only difference is the son and the daughter would categorically mention there that they do not have any objection to getting the flat transferred in their mother's name. This is the only difference in the affidavit of the mother and the affidavit of the son and the daughter. So you have three affidavits made, one of the mother, one of the brother, one of the sister, all on 100 rupees stamp paper. And all of these affidavits have to be notarized as well, which is, a requirement, a mandatory requirement to get them notarized. Apart from these documents, apart from the affidavits, you would also have to make an indemnity bond made by the mother. Now, because the flat is transferred onto the name of the mother, so she'll have to make an indemnity bond on a stamp paper of rupees 500, mentioning that she will indemnify the society and all the legal heirs if they face any losses in future because of this transaction, because of the flat being transferred on her name, because of any objections or disputes arising in future. Now, this indemnity bond need not be notarized. You don't have to notarize this, unlike the affidavits that you've notarized. So all the documents, that is, you have the application by the mother, you have the affidavit of the mother, affidavit of the son, the daughter, and the indemnity bond made by the mother. All of these documents bunched together, you have to make a file of that. At the same time, there are nomination forms of a society. There are certain forms which are required for the name transfer as well. So you have to attach those forms according to the requirement of the society. You will have to pay a nominal fee of like 500-600 rupees via a check to get the membership of the society. Once you submit all of this, once the society approves this, then the mother's name will come on the flat, so she'll be the owner of the flat. At the same time, the share certificate would also now bear her name. So on the share certificate, where X's name used to be, that would be crossed out, and at the back, name of the mother would be mentioned as the holder of the share certificate, member of the society. Now, coming to the second scenario, wherein the daughter doesn't want anything, but she wants the flat to be transferred under her mother's name and the brother's name. So procedure remains almost the same. In this situation, there will be a joint application by the mother and the brother, given to the society to get the flat, transferred onto their names. There would be an affidavit on 100 rupees stamp paper made by the mother, saying the same details exactly, that, her details, then followed by, a brief description of X was the owner, the number of shares that he holds with the society, similar to what was mentioned earlier in scenario 1. And here she will mention that, the son and herself, for her making an application to the society to get the flat transferred under their name, and the daughter has no objection to it. So this would be the affidavit of the mother. Similarly, the affidavit of the brother would be with his details, mentioning that the mother and him are making an application to the society, and the sister doesn't have objection to this. Once the two affidavits are ready, then the daughter would also have to make an affidavit on 100 rupee stamp paper, saying all the same details, at the end mentioning that she doesn't have really any objection to getting the flat transferred in her mother's and brother's name. So these are the affidavits that are required. Now, in this scenario, as the flat is going to be transferred in the name of the mother and in the name of the son, so they both would have to make an indemnity bond jointly, mentioning that, they would indemnify the society, the legal heirs, in future from any losses, if there are any disputes or objections to this transaction that they are doing today to get the flat registered onto their names. In this scenario, also the indemnity bond need not be notarized, only the affidavits have to be notarized. So the application, the 3 affidavits along with the indemnity bond, the nomination forms of the society, or any other requirement by the society if required, you have to all file them together, pay a nominal fee of 500, 600, whatever the society has a norm of. So very, very important thing, once you make this bunch of all the documents, make sure that you take a photocopy of that before you hand over the original to the society. Now, this photocopy set that you have, please make sure that you have somebody like a chairman or a secretary of the society sign in on that photocopy set saying that the societies received the originals from you, so that in future that they do not deny that you've given them such application to get the flat transferred onto the name of the legal heirs. Now once you submit all these documents, once the society approves it, then the flat will be transferred onto the name of the mother and the son jointly. The share certificate will also be transferred in the name of the mother and the son jointly. So they become members of the society jointly. So that's how exactly you can go about getting the flat transferred in the name of the legal heirs of any deceased person, in the state of Maharashtra. But having said that, getting a heirship certificate from the court of law is the best option. This becomes an alternative because you can get the flat transferred onto your name, following this procedure. But you may have difficulties when in future you're trying to sell out that flat, because the new owner, to whomever you are selling it to, the buyer basically, would want it to be done via via the entire lengthy process of getting a heirship certificate. So that is the only thing that you may have difficulties with in future. So then why are we talking about this procedure in today's video? Now this procedure would be helpful for people who are looking to get loan against property from any financial institution. So let's take this scenario. X is no more, his son wants to take loan against property on this flat, on this property, and the financial institution that he's approached wants the flat to be under his name before they can approve the loan. Now there are certain institutions that allow the son to adopt this procedure that we've discussed in today's video under bylaws, and then get the flat transferred in his name, get the membership of the society, and that's when they would approve his loan. So in this situation, this method proves to be very beneficial for the son, because he doesn't really have to go through the hassle of appointing an advocate, going to the court of law, spending a lot of money, and then waiting for like 6 months to 1 year to finally get the heirship certificate, and then he will have to then go and approach a financial institution and get the loan approved. So if there is any urgency, there's emergency that he wants that loan, then perhaps this is the best thing. You follow the procedure under bylaws, get it transferred in your name. So if the financial institution approves that, you get your loan. So this was just an alternative to getting a heirship certificate from the court. Of course, we'll discuss about how exactly you can get the heirship certificate from the court of law in our upcoming videos. So that's all in today's video. I hope you guys find this useful. Do like, share and subscribe to my channel to keep me motivated to bring such videos for you guys in future. Press the bell icon to get notification of my next video. See you all in my next video. Till then, keep learning.